Hello, everyone. Yvonne with Core Realty, and I am excited to be here today and to be able to share with you some great information because, I want to say about a month ago, I had a client who contacted me because their father passed away and dad owned three properties and he did not have a will or a living trust in place. And now the family is dealing with probate and it is extremely expensive. So I wanted to share with you all on how to avoid that pitfall. And I brought my great friend who is super awesome, super cool, and kind of handsome, Mr. Orlando Flores.
Well, thank you, Yvonne, for that wonderful, I don't know if appropriate introduction, but I thank you for that. Again, I'm Orlando Flores. I am an estate planning attorney, and also I do litigation in the areas of trust and estates and conservatorships, some civil litigation also. But I'm excited to share with you some of the information I think that your your clients, future, past, and present, really can benefit from in an effort to avoid some of the things that you and I have talked about that some of your clients have encountered. So I'm very excited to be here and thank you for inviting me.
I'm excited to have you here as well. And I guess one of my first questions would be what is the difference between a revocable and irrevocable trust?
Well, by definition, an irrevocable trust means it cannot be revoked. It is, think about it like concrete. Whatever you put in those terms is set in stone and darn near impossible to change. But the real difference, I think, is a matter of control. Irrevocable trusts are basically set up to make somebody judgment proof. So the way they do that is that they essentially take your assets. You own a house, don't you? Okay. So in an irrevocable trust, essentially what would happen is that home that you own would be placed into a trust, and somebody else would be completely in control of that trust and the administration of every asset in that trust. So, God forbid you ever get sued, you would be judgment proof because you wouldn't own anything. You wouldn't have any control on anything. And so there'd be nothing for somebody to get from you. That doesn't really make a lot of sense from the majority of people, unless you're in risky behavior, you're flying planes, or smuggling this or that, what have you. So that's really not really appropriate. The majority of people really need a revocable trust. You like controlling your house?
Yes, of course.
You're going to rent it out someday and buy another one?
Yes.
Might sell it, might
Yes, maybe.
refi, you might expand,
Right.
renovate. So that's a revocable trust. The revocable living trust, same thing. That's really the best vehicle for you to be able to protect your assets, um, make arrangements for them after your passing for the benefit of your children, your beautiful children, and also be able to enjoy it during life as if you didn't have a trust at all.
Can you give us an example of a situation where perhaps a family didn't have a living trust in place and the owner of the property passed away?
Absolutely. Funny you asked. That's probably the reason why I'm in the area of the law that I am. I used to be in criminal defense, and about 10 years, 12 years ago, my stepfather passed away and was married to my mom and owned a lot of property, had a house, had a boat, had motorcycles, 7 cars, all kinds of stuff, and no will, no trust. And I saw firsthand how really challenging it can be for someone who's supposed to be grieving the loss of their loved one, the love of their life, and not being able to just do that because they have to deal with all these different sort of issues related to property and money and title and things like that. And I saw the pain in my mom, and that instantly taught me that's what I want to do. I want to be able to help people avoid those things by planning for their tomorrows so their loved ones don't have to deal with that at a time when they're supposed to be just grieving.
Oh, thank you for sharing. Now, Orlando, how expensive is that when there is no living trust in place? Like, can it get really expensive?
Absolutely. So, what a lot of people don't realize is they'll think, I have a will, I'm set, I don't have to worry, everything's taken care of. And it's true to a degree, that you brought up the cost. So, in probate court, probate law, whether you have a will or you don't have a will, in the absence of a trust, you're looking at what's called statutory compensation. What that means is that the court is going to appraise the value of someone's estate. And if
Okay.
it's over a certain threshold, I believe it's about $162,000 now. So in Southern California, that's pretty much everybody. If you own a property, uh, they're going to appraise the entirety of your estate and they're going to apply a percentage to it
Hmm.
on a sliding scale that the estate will ultimately have to pay, right, to the
Right.
attorney and to the executor or the administrator if you don't have a will. So, for example, on $1 million estate, which if you have a property and you have some money, it will cost the estate about $46,000 in probate costs in statutory compensation that's split between the attorney and the executor or the administrator. Plus, there's also additional costs such as filing fees for these different petitions you have to file. You have
Wow.
to give publication for a period of time, so that's going to cost you money. And the actual appraisal of a house, right? There's a probate appraiser who will also charge you a percentage of the value of that house too. So pretty easily on $1 million, you're looking at close to $50,000 in statutory compensation that will come right off the top. So mom and dad, the second one to pass away leaves a house behind and estate and this and that. All of a sudden, that $1 million estate is now about 950.
Wow. So would you say that on a scale from 1 to 10, everyone should have a living trust that owns property and has other assets? What type of assets can go into this living trust?
So on a scale of 1 to 10, my suggestion is probably around a 99 that everybody should have a trust, unless they like giving money away to people for nothing, in which case I can give you my business card later and they can have them send it to me. But otherwise, assuming people are responsible and reasonable, which I believe that most people are, you fundamentally absolutely need to have a trust if you own anything, right? And you're talking about all kinds of things. So it's not just the statutory compensation, you also have to think about control.
Mm.
So if you don't have a living trust, and we can talk about what that is, but if you don't have one, you go through probate court. That means all of those assets are tied up
Mhm.
until the court says you're able to pay, use, distribute, or whatever it is that you're trying to accomplish. But that's not until you get a judge's order.
Okay.
So in that time, all the money that's in that account is untouchable.
Okay.
Okay. They have $500,000 in a checking account. It's no good to anybody until the
Mhm.
court allows you to have it. If they have a house, right? You
Right.
probably have a mortgage most likely. But
Right.
now if you don't have access to the checking account, then who's going to be paying the mortgage while this probate goes on? And let me tell you, in LA, they hope that it can take you 13 months or so to finish a probate.
Wow.
So you're talking about over a year. You don't have access to mom and dad's money. The utilities and the property taxes and the expenses associated with that, the mortgage are all due every month. So you're hoping your beneficiaries have enough money, the kids or
Mhm.
whomever, have enough money to keep that going in the interim, right?
Mhm.
I've
Right.
seen a couple of properties end up in foreclosure that way because there was a loan taken out, nobody has enough money to pay it, and now it's come due, 90 days have passed. From your experience in the
Right.
real estate world, banks like to get paid
That's right.
and they don't wait for anybody. So now, on top of everything else, you're grieving, you're going through probate, and now you're losing mom and dad's home or scrambling to try to find some sort of a solution to keep it in the family.
Right.
The kinds of things that can go into a trust are anything really with a title. So you have a boat, you have an RV, you have a car, you have a house, obviously. Probably most importantly are financial institution accounts. So a checking account, if you have stocks and bonds, a brokerage account,
Okay.
um, really anything that you're trying to uh, incorporate into this understanding of what you want done with it, and you give somebody authority to be able to do those things with respect to those assets.
Now, if a family doesn't have a trust in place, what are the consequences? What are the tax implications that may occur?
So again, the biggest now, because of all the changes that have happened in California property law with Prop 13, et cetera, it's a different landscape now. The biggest difference is going to be the time where the kids won't have access or control of all those assets. And the cost that the court is going to impose upon the administration of that trust. I'm sorry, of that estate. The real caveat is that if you don't have a will, then there's this what they call the chart of sanguinity. Big long word, but um, basically the court says if you haven't designated who your beneficiaries are, then we will tell you who they are, right? And you're paying for that process. But what if you have a child who you're not on greatest terms with, or who has, kind of gone off into the wilderness and never came back to you? Well, then in that instance, the court doesn't know anything about that relationship and they're still an heir of yours. So even if a child has been, quote, disowned by their parent, right? Or if they're out in the streets, or if they have social issues or problems, the court's not going to know any of that. And so therefore, their their interest will be divided and given to them as if they were a great child, right? Or what if you want your property to go to a charity or a really, really good friend? Or what if you don't have children and you're not married? Well, then your brother or your sister or your cousin or your niece, those kinds of people might end up with a big chunk of your property, whether you want them to or not. So a lot of it is really identifying what the person wants done with their assets and putting it into a vehicle where that is actually what happens.
Wow. And what is the process? How long does the process take when a client comes to you and says, "Orlando, I want a revocable trust"?
I don't do just revocable trusts. I do what we call estate plans. And estate plans are so much more comprehensive than just your assets, right? Most people are thinking about trusts, and that's a big chunk of it. But nowadays, people are losing capacity, the ability to determine and make decisions about their property, their finances, or their medical decisions and their health, right? So if you lose capacity, then legally you're not able to make any decisions about any of those topics, any of those issues, any of those matters that you encounter. So you have, say, an elderly person, or it could be somebody in their 40s, it's happening now, who loses capacity. Now they own a business and they own a house and they have some checking accounts and maybe they have some other medical issues. Now they have zero ability to make any decisions about any of those things. And if you don't have what they call powers of attorney, then you'd be forced to go to court. And for those powers of attorney, they call them conservatorships. And there's two kinds. There's one for the person, which has to do with your health, and of the estate, which has to do with money or finances. You're looking at around ballpark $5,000 to $10,000 just for that process right there.
Wow.
So an estate plan that I prepare will include a power of attorney for husband or wife, or if it's just by themselves, one person, so a single person. Um, in addition, because you have a power of attorney, you're identifying somebody else to make those choices for you, that you're empowering them and you're giving them all this authority. Then there's also what they call HIPAA laws, which preclude people from sharing your personal private medical information. There's an authorization form there so the doctor can legally give, daughter or son or whomever all this information they're going to need in order to make the best decision possible for mom or dad or whomever it is. On top of that, you get, I include what they call a pour over will. So, pour over will is a document that says if something doesn't get added to my trust, you asked me before, what are the kind of assets that can go in?
Right.
So, say a couple weeks before somebody passes away, they buy a house through you, right? They just bought this dream house. It's on the beach, beautiful view, and it's such a beautiful view that they dropped dead of watching it. Okay. They didn't get a chance to put it into their trust.
Mm.
So then it would have to go to probate,
Okay.
right? And we talked
Right.
about the expenses and the time consumed with that process.
Yes.
So this pour over will allows then that home to be poured into the trust, right? You still have to go to court, but it's a lot quicker process and it's a lot less expensive, much less expensive, and doesn't come with all those statutory compensation that I talked about before. So you can go to court, you have this will, you put the house in the trust, and now it's just like it was already in the trust originally, and you're able to control it, manage it, utilize it, etc. The trustee is, and not have to deal with the court process.
Oh, wow. That's great
On
information.
top of that, you also get what's called a certification of trust, which is kind of like a Reader's Digest version of some of the highlights of your trust, so
Hmm.
that you can go to your bank and tell them, I want to put my personal checking account in the name of my trust, right? What
Okay.
that allows is whenever somebody loses capacity or if they pass away, whoever they've designated as their successor trustee will then have the opportunity to utilize those funds on behalf of the trust estate for the betterment of the estate.
Okay, great. That's great information.
How long does all that take? That really depends on the people. I've done them as quick as a month, 3 weeks to a month. Some people don't like to talk about some of these things
Right.
and put them off, and those take a little longer. So, but it really it depends on how dedicated and motivated the individual or individuals are to make the estate plan to come together, answer questions, and be communicative with me.
Thank you so much for being here, Orlando. I really appreciate all the information that you have provided for
My
us.
pleasure.
And I want to let the public know how important it is for everyone that owns not just a home, but other assets to be able to contact someone like Orlando so that he can create an estate plan that works for you and your family so that you don't have to give your money away when someone passes away.
I would also like to say thank you for having me, because it's truly the reason why I do this is to help people. I don't. Everybody has to make a living, but I'm not trying to get rich doing this. I really want to help people, especially the part of the community that doesn't really know a lot about this area and stuff, that can just take small little measures, to protect their assets and kind of provide for tomorrow, not having to pay all these costs and statutory probate fees, etc. Um, a couple $1,000s can save you a significantly bigger amount of money. And as you know, every client that you send over to me, I give an automatic $500 discount to. So I'm happy to continue that going and help as many people as we can avoid
Yes.
some of these pitfalls, because, frankly, it doesn't have to happen unless you let it happen. And so I'm really actually proud of you
Oh,
for
thank you.
bringing this kind of information to your customers and your clients, so that they can arm themselves with the tools necessary to be able to best strategically approach these decisions, in an effort to kind of, like you said, give as much of their hard-earned money and property, etc. Nobody gave it to them. They give as much of that as possible to their children or their loved ones or their beneficiaries as they choose, rather than as the state, the government, or somebody else chooses. So my hat's off to you. This is such a great idea.
Well, thank you. And just so you know, he also speaks Spanish.
Sí.
Gracias.
Adiós.
Goodbye.